I'd like to begin our session on offshore resource management with a recap of the law of the exclusive economic zone, though perhaps in a slightly more focused way than we've covered it in the past. So there are a number of key concepts I'd like to cover today. We'll go back over the historical development of the zone. We'll talk a little bit about the limits of the exclusive economic zone, its legal status, and the question of how other rights, the rights of other states and unattributed rights, are handled in the zone. And this will form a foundation for the exercise we'll do later. And this presentation will be followed, of course, with another one going into the law of the continental shelf in detail for the first time. All right, so let's start with the historical development of the exclusive economic zone and its presence in treaty law and customary law. So, as we've looked at in the past, the first 200 nautical mile zones are declared in 1947 by Chile, Peru, and Ecuador. And as much as anything else, I mean, there are differing views in the literature about why 200 nautical miles was picked. So, for example, Tanaka says this reflected where the Humboldt Current passed these countries in Latin America, and that was important because it was a particularly rich source of fishing. Churchill and Lowe say, well, actually, it was based on a mistake. Previously, there'd been the Declaration of Panama, which had referred to various interests of coastal states, including security and fishing matters within 200 nautical miles, but for a completely different purpose. Either way, we have these declarations of not zones in the modern sense, but in effect, areas of special interest. In some cases, it was referred to as a patrimonial sea. Then, in 1970, the Montevideo and Lima declarations, again led by Latin American states, support expansive maritime claims which naval powers reject, arguing very strictly for a territorial sea and a territorial sea only. There's a proposal initiated by Kenya in 1972 at a conference in Addis Ababa, which begins discussion around the idea of a zone concerning fishing and economic rights. And that feeds then directly into the UN Convention on the Law of the Sea negotiations, as we've talked about in the past. And before the convention is even concluded, states start declaring an exclusive economic zone in their own national law. That is, the rule has been put up, it has a degree of clarity. States can see the economic advantage to them in claiming it, and it appears that it's going to enter treaty law, so why not do it now? That, of course, though, means that this is an act of kind of rule-making outside treaty, which means it can only really be a matter of custom. So the question then becomes, does the exclusive economic zone exist in customary law as well, or does a version of it? And the International Court of Justice in 1985 said, yes, it does. There's enough state practice in the world and it's sufficiently consistent that we can say that the exclusive economic zone exists as a matter of custom. And let's remember, at 1985, the UN Convention on the Law of the Sea is not yet in force. The text has been concluded as at 1982, but it hasn't yet had enough ratifications to come into effect. All right, but what would be the content of such a customary rule? Well, we'd probably look to the rights and powers enunciated in Articles 56 and 58, and particularly the provision in Article 58 that preserves the application of certain rules of the high seas regime in the exclusive economic zone. Now, it's less clear, perhaps, that all of the duties enunciated in the EEZ regime have necessarily passed into custom. And there are a couple of reasons that might be the case. And I'll just make sure the full text of the slide is visible for a moment. There we are. So Churchill and Lowe give 3 reasons that duties might not pass into custom. States don't always claim those duties in national legislation. National legislation is often inconsistent as between states. And the North Sea continental shelf cases in the 1950s, which first outlined the concept of when rules that originate in a treaty text might become custom, said that while practice might not need to be perfectly uniform, and while a sufficient amount of practice might arise in a very short time, the rule in question should be of a fundamentally norm-creating character. Now, what does that mean? Essentially, it means that we need to be able to state the rule fairly clearly and precisely, and possibly at a relatively high level of generality. Now, that's going to make highly detailed procedural rules much harder to find evidence that they have passed into custom. Okay, let's move on. So, what are the limits of the exclusive economic zone? All right. As we've said in the past, the basic definition under Article 55, the exclusive economic zone is an area beyond and adjacent to the territorial sea, subject to the specific legal regime established in this part, under which the rights and jurisdiction of the coastal state and the rights and freedom of other states are governed by the relevant provisions of this convention. So the first thing to note is that actually the EEZ begins where the territorial sea ends. So the territorial sea itself does not form part of the EEZ, and it's subject to a specific legal regime, an idea we will come back to, and that regime involves both rights inhering in the coastal states, rights and jurisdiction for coastal states, and rights and freedoms for other states. Article 57, the exclusive economic zone shall not extend beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured. So that's a maximum outer limit. And the question is, okay, where then do we draw the boundaries on that? Well, one important issue is the extent to which an EEZ can be generated not just from the mainland but also from islands, and we'll just take us to the full text once again. So something that can be significant in any dispute over the extent of an EEZ is, well, it says measured from baselines, the sort of baselines of territory. Well, territory will include islands. So imagine if you've got an exclusive economic zone running out for 200 nautical miles, then near the limit of that zone you have an island. Well, you might project it still further. Or indeed, you might have an island over which you are sovereign at some distance from your mainland territory, and you could, as it were, enclose a large area of the high seas as your part of your exclusive economic zone. So it becomes very important to know what is and what is not an island, and this is something we'll come back to in some detail when we look at the South China Sea dispute. But for the moment, we have Article 121.1. An island is a naturally formed area of land surrounded by water which is above water at high tide. So that is significant because there are features in the oceans that are only above water or partially above water at low tide. And these are sometimes called drying rocks. Reefs, certain reefs might fall into this category. But the usual technical term given is a low tide elevation, or LTE. So an LTE will not meet the Article 121 definition of an island. Then, except as provided for in paragraph 3, so there's an exception, the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf of an island are determined in accordance with the provisions of this convention applicable to land territory. So whether something is an island or not is incredibly important. And then we have the exception, 121.3. Rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. So that's an incredibly important provision, and it was construed very strictly by the Arbitral Tribunal in the South China Sea Award. Strictly enough that it's a perhaps slightly controversial decision on this point, where the tribunal noted that while strictly the words human habitation or economic life are disjunctive. It's two tests. In practice, the tribunal found that it will be relatively rare that a completely uninhabited island can be held to have an economic life of its own. And in particular, the tribunal excluded any merely extractive activities. So the simple fact that, for example, you can go and fish next to a rock that is uninhabited is not enough to make it an island. And we'll come back to that idea in later classes. All right, so this is a good example of where we can find some of the controversy about what is a rock, what is an island. This is rockall, a feature claimed by the United Kingdom, which was for a long time claimed as an island, which created some tension with other states nearby in terms of it generating a large fishing zone, in particular Iceland. The UK eventually conceded that this feature, which is only about 12 metres high or so, I think, was in fact a rock and not an island, and was certainly not capable of generating either economic activity of itself or indeed sustaining human habitation. All right, it's also notable that there are such a thing as non-independent territories still to some extent. So there are trustee territories, former colonial territories, over which various states may hold mandates, and this is more than a purely historic phenomena. And the idea here is that provisions concerning the rights and interests under the Convention should be implemented for the benefit of the people of the territory, with a view to promoting their well-being and development. And this has echoes in a case we'll look at later, the case between Mauritius and the United Kingdom concerning the Chagos archipelago. There was an agreement at the time of Mauritian independence, when the Chagos archipelago was removed from being technically a part of Mauritius and retained by the United Kingdom, that any mineral rights in the seabed around these islands would be managed for the benefit of Mauritius. And one point worth noting in the Australian context is that as a matter of Australian law, there is an exclusive economic zone proclaimed off Antarctica. It has been recognised by only a handful of states, typically states that have themselves proclaimed exclusive economic zones off their Antarctic claims. There have been efforts, for example, to take action against Japanese so-called scientific whaling expeditions by environmental groups in respect of these EEZs, effectively seeking administrative law remedies to proclaim that the Australian government should enforce its own law in these EEZs. Though the court noted that, one, this was an act of discretion and foreign policy, and two, this would be complicated by the fact that only a very small number of states recognised the legitimacy of the Australian claim at the international level, despite the fact that the zone entirely exists taken purely from an Australian constitutional law point of view. The controversy arises from Article 4 of the Antarctic Treaty, which essentially says, on the one hand, nothing in the treaty shall involve a renunciation of claims state parties have already made, but you may not make a new claim or enlarge an existing claim to territorial sovereignty. The Australian argument has always been, we're not in violation of Article 4.2. It's not a claim about territorial sovereignty. It's a claim of a zone that is a consequence of territorial sovereignty. So in terms of maritime zones, it's often said that the land dominates the sea. You get a maritime zone because you are the territorial sovereign. So this is not, as it were, a new claim of sovereignty. It's a claim of rights that flows from the fact that we have sovereignty. As I say, that argument has not been widely accepted by the rest of the international community. All right, so that's the sort of general principles around where you can draw your EEZ, and obviously when your claim overlaps with another state, you have a delimitation, the potential for a delimitation dispute. And the ordinary principle there is that you'll start by setting an equidistance line and then adjusting it according to any special circumstances. And there's a case law on that we'll come back to when we look at dispute resolution questions. All right, let's recap the legal status of the exclusive economic zone. And we'll do this in 3 steps. So the first thing to note is that during the negotiations, many states were fearful that about creating this new jurisdiction and the consequences it would have, and suggested that the exclusive economic zone should have a residual high seas character. That is, it is a part of the high seas, but the coastal state gets a limited number of special rights. If you look at the text of the convention, it's quite clear that that is not the approach that has been taken. But equally, it's quite clear that it's not effectively an extension of the territorial sea in which certain high seas freedoms are preserved. And indeed, if that were the case, then there'd sort of be a default rule in favour of the coastal state if there was any controversy about regulatory authority in the zone. That is, sovereignty, as it were, covers everything that is not excluded. So one might say, well, it doesn't matter if certain rights haven't been given to us. If the EEZ has a residual territorial sea character, then we can assert sovereign rights. So neither of those approaches were taken. You don't start from the proposition that the EEZ is either the high seas but with special coastal states' rights, nor do you start from the presumption that it's an extension of the territorial sea in which other states are given special rights. Finally, the position adopted at the UNCLOS negotiations was that it is a sui generis functional zone, and we have the 3 principal elements. Rights and duties are conferred upon the coastal state. Second, rights and duties are allocated to other states. And third, there has to be a formula for regulating activities that don't fall into 1 or 2. So the rights and duties of the coastal state. So let's just consider these in slightly more detail. The basic proposition in Article 56 that the coastal state has sovereign rights to explore and exploit the seabed resources found in the exclusive economic zone is essentially the same position as we find in the Geneva Convention on the Continental Shelf and customary international law. And that's certainly the case in respect of non-living resources. The one thing to note here is that there is a presumption that one has rights in the seabed irrespective of whether there is physically a continental shelf there or not. We'll come to the continental shelf more in our next session. As regards the living resources of the exclusive economic zone, we've already been over these in some detail. There's a detailed series of articles spelling out rights and responsibilities in respect of managing and conserving the living resources of the zone. But powers conferred on the coastal state also include jurisdiction over other economic uses. And that phrasing is deliberately open-ended. It's not limited to making use of wind energy or tidal energy. It will allow states to adapt to changing technology over time. Also, the coastal state has the exclusive authority to build or license the building and construction of artificial islands and installations, and it has certain powers as regards marine scientific research under Articles 56 and 246. These are worth taking a look at. There is a question that's raised by the phrasing of Article 246, which is essentially that if research is directed at resource exploration or exploitation, coastal states have absolutely exclusive authority over such research. However, if the research is, as it were, intended to further scientific knowledge alone, pure research, then states must apply for coastal state approval, and coastal states are typically meant to give such approval, and indeed a researching state might be able to go ahead and do it anyway if there isn't a yes or no decision within a certain period of time. So the convention is meant to be biased in favour of pure scientific research. There are two problems with the system. The first is it's not easy to draw a line between pure research and applied research that might lead to the extraction of resources, and quite often it will just be a question of who has access to that data rather than the nature of the data itself. And the other point is it is still open, even in the case of pure research, for a coastal state to refuse to give permission for research. So this is an area where there can be quite a bit of controversy, particularly if the quote-unquote pure research is being conducted by, for example, a naval vessel. And one might say this is being done for purposes of safety and navigation, and not as a matter even of scientific research. It's being done as a hydrographic survey. And there's some textual support in the Convention for the idea that a hydrographic survey is different from research. Nonetheless, the whole idea of military research vessels creates a number of tensions and possibilities for conflict, as we'll see in our sessions on military uses of the oceans. And also there's the pollution control regime under the law of the sea extends into the EEZ, and we'll cover that in further classes. All right, essentially the rights and duties of other states in the zone boils down to questions such as we've seen before. A limited bundle of high seas freedoms apply in the exclusive economic zone by virtue of Article 58.1. In the EEZ, all states have freedom of navigation and overflight and the laying of submarine cables and pipelines, and other internationally lawful uses of the sea related to those freedoms. And we've already studied in some detail freedom of navigation on the high seas. And when it comes to cables and pipelines, it's worth noting that international seabed cables are regulated further by Articles 112 to 115 of the Convention, and pipelines by Article 79. All right, so finally, what have we got? What are some of the potential controversies here? Well, Churchill and Lowe note that there are a number of questions where we could say, well, here's an activity, here's something states are interested in, who gets control over it? So, for example, historic wrecks have, for example, of a government vessel, or there are provisions dealing with them as preserving, subjecting them to certain coastal state rights within the contiguous zone. But outside the contiguous zone, one might say, well, is a government vessel on the seabed a resource that the coastal state should have access to because it's physically on the continental shelf, or should it remain subject to the authority of the flag state? There's no clear answer either way in the EEZ regime. Now, what about the emplacement of things that aren't artificial islands or structures per se on the continental shelf? For example, sonar devices used as a sort of forward array for detecting the movement of submarines. The other possibility is, well, what about buoys or floats used for pure scientific research? These are a real thing. The Argo program involves a whole lot of autonomous floats and gliders that have been released into the world's oceans. They are taken where they will go by the currents. They're not directed. So they have a scientific research purpose on the high seas, but technically shouldn't move into an exclusive economic zone without permission being granted, and yet they will. But is this really something that should be subject to the regime applicable to scientific research conducted on a vessel? Are these pieces of equipment captured by that regulatory regime or not? So these are just some of the hypothetical examples one could come up with of activities occurring in the exclusive economic zone which do not appear to be expressly regulated. So I've mentioned before the terribly poorly drafted Article 59. So in cases where this convention does not attribute rights or jurisdiction to the coastal state or other states within the exclusive economic zone, and a conflict arises, the conflict should be resolved on the basis of equity and in light of all the relevant circumstances, taking into account the respective importance of the interests involved to the parties as well as the international community as a whole. This would appear to be an open-ended test which would allow for judicial lawmaking to fill a gap. Because who else is going to decide what equity in all the relevant circumstances dictates, or how to balance the interests involved of the parties and the international community as a whole? As I've said before, Professor Natalie Klein describes this provision as being devoid of normative content absent third-party adjudication. That is, it doesn't say anything unless a judge tells us what it means. And have judges been keen to tell us what it means? Well, the answer is simply no. Particularly in MV Sager number 2, the International Tribunal for the Law of the Sea said, that in the view of the tribunal, recourse to the principle of public interest as invoked by Guinea would entitle a coastal state to prohibit any activity in the EEZ which it decided to characterise as activities which would affect its economic public interest or entail fiscal losses. So you'll recall Sager number 2 involved the question of bunkering at sea, and Guinea's, that is, refuelling fishing vessels or other vessels at sea. And Guinea's argument was it was losing money and its environment was being endangered by refueling at sea, rather than as opposed to if the refueling had occurred in its ports, which would have been both safer and have raised tax revenue for it. The tribunal went on to say this would curtail the rights of other states in the exclusive economic zone. The tribunal is satisfied that this would be incompatible with the provisions of Article 56 and 58 of the Convention. Note that they said doesn't fit within 56 and 58. They didn't even go to 59. They just said the use being asserted in by Guinea in MV Sager number 2 means just simply doesn't fall within the Convention. And in the similar later Virginia G case, it was found that the bunkering of fishing vessels could be regulated as an incidental activity related to fishing. So again, the tribunal in the Virginia G case ducked the issue of whether it should apply Article 59. And so the issue of bunkering still hasn't been ruled on, though apparently any activity of bunkering, refueling at sea, that's closely related to an activity within coastal state authority, that can be regulated as an incidental aspect of the activity, but bunkering in general so far is not. Yes, and here we have the summary of the Virginia G case. So at paragraphs 213 and 15, the tribunal emphasises that in the exercise of sovereign rights of the coastal state to explore, exploit, conserve and manage living resources of the EEZ, the coastal state is entitled, under the Convention, to adopt laws and regulations establishing the terms and conditions for access by foreign fishing vessels to its EEZ. The tribunal, however, is of the view that it is apparent from the list in Article 62, paragraph 4 of the Convention that all the activities that may be regulated by a coastal state, there must be a direct connection to fishing. The tribunal observes that such a connection to fishing exists for the bunkering of foreign fishing vessels in the EEZ, since this enables them to continue their activities without interruption at sea. So in that particular case, bunkering was found to fit within Article 62 because it was closely related to fishing, and therefore the tribunal didn't have to consider the application of Article 59, and that's where the case law remains. Alright, so that's the basic outline of rights in the exclusive economic zone. For the purposes of the activity we'll do, it would be useful to read in some detail Article 60 on artificial platforms and installations. And please watch the next video on the continental shelf. Thanks.